Okay, 1, 2, 3.
Hi, my name is Shoshie Goldstein-Nissenbaum. I'm a Toenet Rabbanit, a halachic advocate, and a mediator. And today I am honored to have the Honorable Judge Marcus join me on my podcast, Divorcing with Dignity. To introduce Judge Marcus properly would take me a long time because he has quite an impressive resume. Um, Originally from England, he made Aliyah in 1978. And after 15 years of being in private practice as a lawyer, he was appointed to the judge of the family court in 1995. I highly recommend you check out his website, where he has a lot of amazing information and insights into how the family court works, and also what we're going to talk about today, which is rights, parental rights. What does that mean? What are the rights of the children? Since his retirement in 2012, and I call it retirement, he's not really retired, because I think maybe I'm wrong, but I think you're more active now than you ever were, is really making a mark on the world in terms of making sure that children are taken care of in the process of divorce. The effects on the children, how parents can curb that, and how parents could divorce in a dignified way and do what's best for the child at the same time when they're doing what's best for them. So I'd like to start with a quote from Judge Marcus's website, where he writes, "A right is defined as the claim of entitlement that can be demanded in legal proceedings. What is common to the present terminology is that it leads to the perception that on paternal separation, the rights of the parents need
Parental
to be
separation.
Parental
Parental
separation, the rights of the parents need to be sorted out by judicial intervention, unless the parents can reach some compromise, which can only be achieved if one or both of them relinquishes some rights they have. This approach makes the parents, at least at the start of the discussion about the effects of their separation on the children, face each other in an adversarial stance, which is the opposite of what the children need. The children need their physical, developmental, psychological, and emotional needs to be provided by their parents." So now I want to turn the floor over to you, Judge Marcus, and I want you to elaborate on that and help us being able, that divorced parents should be able to stay focused on the best interests of the children.
Thanks very much for inviting me to speak today. It's extremely important that parents should understand that they have no rights. In my opinion, the term rights is something which is new. It started in the present way it's understood sometime towards the end of the 18th century, French Revolution, the American Revolution, but it doesn't represent the values which are, in my view, appropriate for all parents dealing with their children, and indeed all kinds of relationships. And you won't see the terminology of rights anywhere in the Jewish sources, not in Chumash, not in Tanakh, not in the Talmud. It's a new idea. Our philosophy, and I think it should be the same for peoples of all kinds and all religions, should be based on responsibilities. That means duties and obligations. And in the particular case of parenting of children, parents, as soon as they decide to have a child, take on themselves responsibilities which do not end until each child reaches the age of majority. And in fact, anybody who has married children and grandchildren knows that the responsibilities continue beyond the age of 18. These responsibilities which parents take on themselves, as I say, they start with conception, and they require that the parents work together in order to properly bring their children up. And in the specific areas which I'm concerned with, that involves their emotional and psychological health and welfare, regardless of whether the parents are married or not married, they were married, they're divorced, separated. These responsibilities continue in full force as long as the child needs them. What this means is that parents, if they decide to separate, should first and foremost consider how they are going to continue to carry out their duties and obligations, their responsibilities to their children together, even though they may be living separately. The responsibilities are joint, they do not cease to be joint. And in fact, in the Israeli law, starting with a law for the equality of the rights of women in 1951, the way this is expressed is that parents, the biological parents, have joint responsibilities for the guardianship of their children. That was repeated in the custody, in the guardianship and legal capacity law of 1962, and it continues in full force in Israel to this day. There's one more thing, which I think is also critical in the terms of the debates that go on and the decisions that parents have to make. And that is the word custody is totally inappropriate in terms of what happens to children after the parents separate. Custody in our legal system means somebody who's in prison. You talk about someone escaping from legal custody if he runs away from the police or a prison. Or you put your diamond necklace in the custody of your banker to look after it. You don't have custody of your children. You have responsibilities to the children. And following from that, the idea of visitation is also totally inappropriate terminology. You visit somebody who's sick, Khalil, or someone who's in prison. You don't visit your children. You hug your children. You love your children. You spend time with them. So that my conception of what happens after parental separation is based on joint continuing responsibilities, and also that the parents spend time with their children, and that, as well as all the other things they have to sort out, that should be sorted out by them without resort to lawyers in the first instance. They get up in the morning, someone decides they want to separate and divorce, they shouldn't rush off to a lawyer as the first thing. They should rush off to a counselor, somebody who understands the needs of the children, somebody who understands the needs of the parents, and somebody who can help them to reach an agreement as to where the children are going to be on each day, who's going to take responsibility for decisions relating to the children's education, health, welfare, and all that. And that should be the default. Unfortunately, for the last 150 years or so, we have been inundated with the message that separation is a legal matter. It isn't, essentially, certainly not at the beginning, a legal matter. It's an emotional, relational matter. And some of the senior judges in the world and some of the senior lawyers have realized that. And that's why there should be an immediate referral to someone who can help parents to sort out what's going to happen with their children. And the law comes afterwards in those difficult cases where the parents cannot reach agreement.
So what I just want to add that in halacha, there's a very, very clear halacha, which has evolved and has been clarified over the years. It says that the girls stay with the mother, and the fathers are with the boys, and all the children are with the mother until 6 years old. And what's all of the parshanut, and this is going back to even Rishonim who talk about it, that it's not the right of the father or the mother. I saw this in the Rashba. It's not the right of the mother or the father. It is what is best for the child, and therefore the Beit Hadin needs to, this is the recommended, and of course that was written when fathers had much less to do with raising their children, which today fathers are very involved in raising their children, much more than they were in the times of the Rishonim, that's for sure. And the halacha is very clear that the Beis Din must decide what is best for the child, and that it has all of those halachot are all based on what is best for the child. So in what you described, Judge Marcus, is the amazing utopian way to divorce. But unfortunately, many people listening to this podcast are in divorces in which they don't have a partner. One of the reasons why divorcing is because they don't have someone that they could actually have a real conversation with. They don't have someone who they could communicate with. They have a partner who's unfortunately mentally ill, or who is not functioning right now, or who is very hurt from the marriage and has decided to use the children or the argument of the children, whether it's consciously or subconsciously, as a way to get back at the spouse. Okay, we also have, so how do me as a Toenet Rabbanit, how do my clients, what do you do when you have a partner, a father or a mother, and it goes both ways? Sometimes it's the mother who makes a lot of trouble, sometimes it's the father who makes a lot of trouble. How do you deal with a non-partner where your only way to get them to comply is through legal ways, methods, and it goes for both ways. Sometimes we have one parent who doesn't want to take responsibility, who doesn't want to have anything to do with the children, and sometimes you want a parent who wants more than their 50%, or they want 60%. So what would you recommend then?
Look, so you asked a question which has several parts to it, and I'll try to answer. First of all, it's true that many couples separate because they cannot get on, and that can be for many reasons. One of the projects that I'm working on is that adolescents should be helped to choose the partner with whom to have children, with whom to get married. And there are certain signs that can be picked up if these young people are sufficiently trained and educated, that on the third or fourth date, you can often work out that this is somebody that really you're not going to be able to get on with. But given the situation where couples split up, and I agree with you, in some cases there are mental disorders, in some cases, perhaps even more frequently, there are personality disorders, which are a different thing, which makes a logical, regular conversation very hard. In that case, there is no alternative but to go to the court or the Bet Din. To go back to the start of your question, the presumptions that boys and girls should be with the mom until the age of 6, and then girls should be with the mom, that is a presumption where all other things are equal. I can tell you on the basis of my experience as a lawyer and as a judge and reviewing the literature, the psychological child development literature, the social work literature over the last several decades, that it's extremely rare that all other things are equal. And that depends on, of course, the personalities of the parents. It also depends on the personality of each individual child. And it also depends on all kinds of other circumstances. So that while these are presumptions, Chazal and the Rishonim and the Achronim and the Poskim of this day realize that the central issue is what this particular child needs, and the ability and the availability of each parent to give the child those needs, and the ability to collaborate, to work together with the other parent. So these are all matters which the Bet Din and the court will consider, and the presumption, the tender years doctrine, is really a default. And in terms of the case law, both of the courts and of the Batei Din, it's a starting presumption, but it doesn't really go to the needs of any specific child. Also, the idea of 50-50 split, while it sounds very elegant mathematically, it's practically impossible to do. You cannot, without counting hours and minutes and seconds, decide that a child should be 50% of time with dad and 50% of time with mom, because the child is in school part of the time, and the child's with friends, and the child's in chugim, and the parents are busy, and the dad has to go to miluim, and the mother has her things to do. So the idea of a 50-50 split, which was actually tried in the legislation in Australia, and they had to revoke that legislation, abolish it after 5 years, because they found it simply doesn't work. The idea of 50-50 is, in my humble opinion, nonsense. What you have to do is to work out what the child needs and how the parents are supposed to answer those needs. Now, to your question, what happens when, as you say, there's no one to talk to? The answer there is that you have to persuade the other party that the way to deal with things is by talking. And that can be by, for example, there's a system called collaborative divorce, where the parties each appoint a lawyer, and they can then conduct the negotiations, and they can have discussions with experts on childcare and financial experts and so on. And these lawyers undertake not to take part in any litigation that might happen afterwards. If you can find a lawyer or a Toenet Rabbanit who is into the idea of collaborative divorce, and the other side also has a lawyer, then the lawyers together have an interest in bringing about an agreed settlement, which they can then present to the Bet Din or to the court. If that fails,
I'm actually I have a certificate in collaborative divorce. I took quite a number of amazing courses on it, and I've done it a few times. It is absolutely the best way to go. There's no question, because there
yes.
you bring in what collaborative divorce is, as Judge Marcus described, is each side has a representation. Okay, their representative is not in the litigation mode, but in the mediation mode. And it's very clear that this is all for the benefit of the children. What is the best interest of the children? So in collaborative divorce, we have consultants who we consult with, a child psychologist and who knows the children, who's met the children, met the parents, understands the needs of the child, and can make not only a schedule for the child that's going to be the best for the child, but also help the parents explain to the children what is going to happen, what's going on. They guide the parents through the process, which is an incredible thing. And then also post-divorce, because there's always some things that need to be ironed out. After post-divorce, kids grow up, they become teenagers. They're not the same 6-year-old as they were before. And now they say, I don't want to go to Ima, or I don't want to go to Abba. So that also, again, it's always what is best for the child. And also financial advisors as well. In other words, how can we split this pie into slices that are going to be as fair as possible? And maybe it's not going to be a 50-50. Maybe there's some things that are sentimental that, one side doesn't want to sell, or all those types of things that come. It's definitely the best way to divorce, in my opinion. The only problem is that most of my clients can't afford it because it's expensive. But what I'd say in the end is that you can either pay it now, or in the end, you can pay a lot more to a lot of therapists and running around to gemachim and looking for more money, because things aren't going to be divided in a way which is sustainable. So it's like, penny, how does the expression go? Penny wise, pound foolish.
That's exactly right.
And that's what ends up happening.
Yeah. So let's move on. Supposing that collaborative separation and divorce are not possible. In that case, you need a lawyer who is obviously going to advocate assiduously for your position, but also a lawyer who is aware of the likely effects of litigation on the children. And that attitude is extremely important when selecting a lawyer, an advocate, because unfortunately, like all oceans, there are sharks and minnows, and there are lawyers who think that the objective of their profession is to crush the other side, to destroy the other side, and that may be okay if you're involved in civil litigation for an amount of money. It certainly isn't true when the other side is the parent of children who are also the children of the first side. So that in finding a lawyer, it's important to establish that lawyer will have the children's interests at least in the background, and will not take action which is likely to antagonize the other parent to the extent that it's impossible even in the future to consider working together in the interest of the children. So that's as regards selecting the lawyer. We have in Israel, which is almost unique in the world, two parallel systems which both involve judges and dayanim who are specialists in the field. My colleagues in the United States tell me about judges who are either elected on a party slate and then they're shoved into family court as part of a rotation. In some places, the first rotation for a newbie judge is in family court. Not only does he not know anything about child development and what goes on in relationships in families, but also doesn't even know how to run a courtroom. And they cause a tremendous amount of suffering and damage. In Israel, in order to be a judge in the family court, you have to have established knowledge and experience in the field as a lawyer. And in order to be a dayan in the Bet Din, they have training. Many of them now have law degrees, and at least the courts are aware of the needs of children. The Batei Din and the Batei Mishpat have the family court social services, social workers who are trained in the areas of child development and dispute resolution. And to that extent, the court is available and will listen to arguments in regards to the needs of children. That does not mean, of course, that all cases are resolved amicably, but it's important that the children's interests should be taken into account at every stage, and there should be a consideration of what the likely effects on the children might be of litigation. What has to be remembered is that children are automatically affected by separation between mom and dad. The home, which they regarded as being their base and a firm grounding, has fallen away from under their feet. They are understandably concerned and nervous about what's going to happen in the future. And the longer they are concerned about the future, the longer they are worried about what the outcome is going to be, the more difficult it is for them, both at the present, but also in the future. Because it's a matter of, I think, common knowledge that children of divorced parents have less trust in relationships, and it makes their life more difficult and their life with their children in turn more difficult. So that there should also be an accent, an emphasis on reducing the length of the uncertainty for the child as far as possible. That also requires lawyers to realize, and of course judges and courts to realize that there's very important that cases involving children should be settled or resolved as early as possible. So we're talking here not only about the effects of litigation, but we're talking about the basic problem to be a child of separated parents, and clearly, if the litigation involves heating up the dispute rather than cooling it down, the effects on the children are going to be much more serious. So that's the second stage. The third stage is, on the other hand, to call out any behavior by a parent which is clearly going to adversely affect the child. What that means is that when a parent is deliberately or as a result of a disorder of personality doing things which adversely affect the child, then the other parent and the lawyer should approach the court and insist that things be straightened out and things be done properly. What that means is, for example, when there's an order of the court or the bet din as regards contact, and that's being disobeyed, then the court should be approached to impose proper sanctions in order to ensure that contact is going to be preserved. Because one of the principal responsibilities of separated parents is to ensure that the child has a good ongoing relationship with the other parent and the other parent's family. That's part of the responsibilities which parents take on themselves simply by having children.
I think that's a very difficult point for a lot of divorcing parents. Because what you said now is that it's not just to keep the schedule, which is decided upon between the parents of the court, but to actually actively encourage a good relationship between the child and the other parent and the other parent's family. And that's a lot of parents, when they're divorcing, they confuse this concept of that they're divorcing, but children never get divorced from their parents or from the family. Grandparents, aunts and uncles, cousins, which are a great asset to the child. When their family is crumbling, they have this great support system, which it doesn't mean that the extended family knows what to say, but just by their being there and then joining their smachot, that is a support for the children. It's something that people find very difficult to do because a lot of divorcing parents believe that they are protecting their child from the other parent. And that's why if you ask them why they're getting divorced, because I want to protect my children. Now, sometimes it's true, right? The other parent is abusive, verbally, emotionally, physically, and they really do want to protect their children. But divorce is not necessarily, I mean, this is maybe a question, an observation for me. Divorce doesn't necessarily protect your children from any of that. Meaning, divorce actually might give you less observation, when you're living under the same roof. I'm not saying not to divorce because of this. I'm just saying I don't see how divorce gives a child more protection from the abusive parent.
Look, you have to understand this concept of harm and abuse. There are historically the things have developed in the following way. It wasn't until the early 1960s when the medical world and the psychological world was prepared to believe that a parent would inflict physical harm on the child. They thought that, you know, if the burn was 8 millimeters circular, that might have come from the open door of an oven, when we now know that it can only be inflicted by a cigarette, and that a spiral fracture of the bones of the lower arm can only be done by the arm being twisted. It doesn't happen when you fall off a bike. It wasn't until the 70s and 80s that the medical and the psychological world was prepared to accept that there could be sexual abuse in the family. And it's only in the last 10 years or so that we're getting to a much better understanding of psychological maltreatment. And that psychological maltreatment can include depriving a child of proper relationship with a normative or fairly normative parent for whatever the reasons may be. So that's the first issue on what exactly is abuse. Preventing a child from having a good, loving relationship with a previously loved parent is psychological maltreatment. The second issue is, as you say, protection. And even in those cases where there has been abuse, violence, whatever, that, generally speaking, does not require a total cutoff of contact between the child and the parent who's inflicted that. There are all kinds of methods of protecting a child who has contact. It can be in a contact center. It can be supervised contact, supervised by a relative who's trustworthy for both parties. In an extreme case, it can be restricted to electronic contact by phone, Zoom, Skype, whatever. The cases are exceptionally rare where there should be no contact whatsoever. Unfortunately, certain interested groups take this idea of harm and abuse to extremes. And they say where there's ever been any kind of nastiness in the family, so the child needs to be protected, and the way to do that is to cut off all contact. That unfortunately has infected certain legal systems, including in England and Wales. I'm consulting with a group in England and Wales where that's become the norm. So there has to be an understanding that protection of the child does not mean usually reducing or restricting contact with the other parent. As I say, there are certain mentally ill parents who cannot keep themselves from abuse, but in those cases, the court should be asked for orders which are limited in time in order to see whether there's been any improvement by treatment and consultation and so on. The next point is this, that any attempt to protect a child by reducing contact, particularly where there are allegations by one parent against the other, this causes a psychological split in the child. The child realizes that he is the fruit of two parents. And if one parent is painted as being evil and black and dangerous, the child grows up thinking that part of him is a half of him, half of his genes are from a dangerous or violent or mad person. That's no way to grow up. And therefore, these allegations have to be made in a very restricted way, and only when it's absolutely essential. The final point is that it's part of the development of a person's identity, which relates to the people around him or her. The attachment theory, which is now very popular, says that a child in utero is attached to the mother, then the father, and when it grows up into be a small child, siblings, and of course grandparents, who play an extremely important role in developing the identity of a child. There are all those jokes about, why are grandchildren and grandparents such friends? It's because they have a common enemy. You want another cookie, you want another sweet. So, grandma and grandpa always say yes, and mom and dad say no. But the grandparents also, they are very important for rooting a child in his or her identity. And the extended family is also highly important. My colleague, Dr. Yoa, from the joint Brookdale Institute, wrote her doctoral thesis on the importance of grandchildren to children whose parents are separated. Yoa Sorek, her name is. So that separation from the parent is bad enough in itself. Separation from the grandparents and the uncles and aunts and cousins is also, it affects the development of the child's identity and personality. And therefore, I'm greatly in favor of involving grandparents in an appropriate stage in planning for the child. Sometimes, of course, grandparents will line up behind their child. Sometimes they'll line up behind the child-in-law because there are all kinds of unresolved problems in the family of that parent. But in general, they can be extremely helpful, and there should be an attempt by a lawyer at the intake stage to establish those individuals who can give support to the child and a sort of refuge from the conflict.
I'm sure you know this already, but the statistics that the Beit Hadin publishes every year of how many divorces there were from each city, and how many divorces there were from Anglos versus native Israelis. So the Anglos are very, very high. Okay, they're much, much higher every year. I don't remember the exact number, and I didn't see this past year, 2023 statistics, but for the past 4 or 5 years, the Anglos have, and not necessarily Anglos, Olim, have been much higher than native Israelis. And that creates a real, first of all, we have to understand why that is, but putting that aside, based on what you just said, that children of divorced homes need support. So the Olim are not necessarily, they don't have necessarily grandparents here, aunts and uncles, cousins. They might have very limited contact with their family as it is, which is just going to exacerbate the other problems. I want to just go back to one thing you mentioned at the beginning of the podcast, when we were talking about terms, custody, visitation, and how that's really old school. We don't use that. A child is not property that's transferred from one parent to another. And there's no such thing as visitation. Visiting is a guest. A child has to have a home. One thing that I try to include in all of my Heskemei Girushin, divorce agreements, is that the child will have everything they need in both homes. They have 2 toothbrushes, they have 2 uniforms, they have 2 Shabbos outfits, 1 in each home, Shabbos shoes, because when I see a child going with a suitcase to a father's house, to a mother's house, it hurts me. And this idea, actually, I got this from the Lubavitcher Rebbe, who was very makpid that a child's school bag should never be heavy. Because if their school bag is heavy, they feel it's a burden to go to school. It's heavy on them. And when a child is going to their father's house or their mother's house, they're not going on a trip. They're going home. They have 2 homes now. So each, and then it also presents a lot of, it prevents a lot of post-divorce fighting. Well, she didn't come back with her Shabbos shoes and they were $50. And where is it? A child should have, a divorced parent needs 2 homes, Abba's home and Ima's home, and they have everything they need. And it costs money because you had to get 2 sets of books, school books, which is a fortune. But again, that money is an investment in your child. It prevents them from feeling that split of, and a lot of my clients fight me on that. They're like, no way, I'm not buying clothes for my kids. I already paid for it. No, you need to have 2 pairs of pajamas, and that's it. Like, that kid has 2 homes now. And I find that post-divorce, it actually is it's very effective, and also avoids a lot of fighting between the parents. Another thing I want to ask you, and maybe we'll conclude with this, is that, so if I understood correctly, Judge Marcus was saying that there could be a parent who is abusive in a certain way, okay? But on the other side of the scale, preventing a child from having a proper, healthy relationship, natural relationship with that parent is also a form of abuse, because abuse is taking away what the child needs to thrive and putting them in a place where they can't thrive, whether it's emotional, physically, etc. So how does, I'm asking for myself also as morally obligated, when you have certain types of abuse that are also really hurting the children, and professionals, I'm not talking about the parents, because the parents are nogea b'davar, they're blindsided, even if they say they're not, right? So you have a father or a mother who is abusive, okay? And it's a harder situation when the mother is abusive, because the courts do not want to believe that a mother is abusive. Even in our progressive days today, it's much harder to convince a court or the revacha that there's abuse going on by the mother, where it is much easier to convince a court or Beit Hadin or the revacha that there's abuse going on by the father. But you have mothers who are very verbally abusive, emotionally abusive, they're not well. And so how does a parent judge and say, you know what, I'm going to let this go. I'm just going to let this go. Even if it really is abuse. I'm not talking about, light stuff. And I'm not talking about physical abuse right now, which is very easy to prove. I'm talking about verbal or emotional abuse, which has been called out by a professional. How does a parent make that decision? When am I going to really bring this to the court? Or is it just not worth it? Because in the end, the children are not going to have their father or their mother as much as they should. And I'm just going to be in months of litigation, prolonging litigation, and the result is going to be the same as if I would have just kept my mouth shut.
Right, you've raised two or three issues there. First of all, I'm not aware of the statistics about Olim, but I can certainly understand that the stresses of moving to a new place, particularly without the support that people have where they come from, can exacerbate differences and problems which may happen. The community has to try to get involved here, but of course there are people who don't like busybodies. They don't like people getting involved, and in those cases, this is the mitziut, this is the situation, and parents have to handle those things with the best of the equipment that they have. There are plenty of social service supports in the voluntary sector as well as in the governmental sector to help these people, but it may not always work. The second thing, I agree with you entirely, there should be two homes. The logistics of moving from one place to another, in Israel at least, are far less than they are in the United States, where a kid in Los Angeles doesn't have to be put on a plane with a stewardess for a 4-hour flight to the East Coast. Each time there's contact. Here, the distances are much less, but even so, I place a great deal of importance on the need for parents to live as close to each other as they can, and any attempt without agreement to remove a child from one place to another, which might reduce the level of contact with one of the parents, has to be dealt with very carefully on the basis of the needs of the child, and the court needs to be made aware of the needs of the child for contact, and any distancing can be considered to be maltreatment of the child unless it's for extremely good reasons. The third point you make about letting go is extremely important, and it's essential to get the best advice, the best therapy, the best consultation as to what this child needs. And no two children are alike. It may be in one family. There are some children who are more adversely affected and some who are less affected. I learned a great deal about what happens to children from the late Professor Gerald Kaplan, who was a child psychiatrist, and he came to the conclusion, actually after dealing with the children of Holocaust survivors, or children who were Holocaust survivors, that 70% of children survive. He called them invincible. But that leaves 30%, which is a lot of children who are adversely affected. It may be in one family that some of the kids are less affected than others. So that has to be borne in mind. There is a developing field as to when a parent should let go, when a parent should say, look, I don't have the emotional capacity, I don't have the funds, I don't have the ability to continue fighting. But it's very important that the child should be aware of the reasons, if not at the time, then later on. In other words, there should be, even if a parent says, okay, I'm not going to see the child, there should be letters and there should be communications and presence. The other parent should be required to hand on these messages and to pass them on. There are some judges around the world who will write a letter to the child or to the children explaining the decision, why the court came to the decision, that the court took into account the needs of the child, and this child will be exposed to the letter when it reaches the appropriate level of maturity, so that the child will understand that it isn't the judge who cut off the child from the parent, But it was done after very seriously considering the needs of the individual children. I saw a judgment only last week from England where a judge in a very difficult, contentious case wrote a letter to two youngsters to be given to them when they reach a certain age to explain why the court reached the conclusion that it did. Because that may help to assuage the fears of the child. It's certain that children of a certain age, it may go on into their lives, may feel responsible for the breakup between the parents. If only I had behaved properly, or if only I hadn't been ill, then mom and dad would still be together. And it's very important to reduce that feeling or to nullify that feeling because it can accompany a child into adulthood. So here are some clues or tips or ways in which it can be done. You know, the larger the network is of contacts, then the better it is for the child, even where a parent feels that they simply, you know, it's not worth fighting. That means that personality disordered parents can win, but we're not talking about winning. Nobody wins in a separation case. The children always lose. And the question is to minimize their suffering and minimize the effects on them as far as possible. That's the job of the parents.
Well, thank you so much. Thank you for giving us of your time and your
Great pleasure.
Your treasure of experience and knowledge. And if even one person listens to this and makes a better decision for their children, you saved a life today.
Yeah.
So thank you so much. Thank you for joining us.
Great pleasure.
In all your endeavors.
Kol Tuv.